But the first, I want to give a shout out to our colleague in Queens, David Kim, because he got a big win in Jang v. Garland out of the Second Circuit on May 9th. And it's a real heady one about CIMTs and this BIA decision called Matter of Tejwani, which I'm not going to get all into now, but suffice it to say, Matter of Tejwani is no longer good law. And really, it's kind of amusing because, like, even the statute that Tejwani is analyzing apparently changed a couple of years later. So, like, that's, you're going to be in big trouble trying to rely on that statute. But it's important because, in essence, this statute, the Second Circuit held, contrary to what the BIA held in a published decision, that this statute of second-degree money laundering in New York is not a crime involving moral turpitude. And, you hear money laundering and you're going to be in big trouble. Usually it's a pretty serious provision. I'm currently doing an analysis right now for a case. I mean, there's no waiver for money laundering, and the CIMT provision's even less. So you would think money laundering is going to be a CIMT, but here's why the Second Circuit said it's not, and why it's important no matter what case, no matter what statute you're analyzing. It's because this money laundering statute in New York, the second degree, it requires knowledge of a crime and concealment of the crime. Okay? Oh, John, did you go away?
No, I'm here. I was doing videos.
It requires knowledge and concealment of a crime, but it doesn't require the specific mental purpose to conceal. So even though you have knowledge and even though you conceal, you don't necessarily have the intent to conceal or the intent to defraud. And that is what's required to be a CIMT. The quote is, a statute that, quote, provides that the intent requirement is satisfied merely by knowledge that the financial transaction is designed to conceal. It's not going to cut it. That's a paraphrase of a quote. And so it really, when you get these cases, CIMTs are hard, CIMTs are difficult, but it really comes down to what the mental state is, because state crimes, states, they're almost always going to try and over-criminalize, try to encompass as much conduct as possible, and try and have a lessened mental state or mens rea, because it's hard to prove specific intent in criminal court when the government has the burden. But that's really going to help us in immigration court, where we usually have the burden, the non-citizens, because if a statute is covering more than the specific intent to defraud, even just knowledge of criminal activity going on, you might not have a CIMT. And that's what David Kim just won at the Second Circuit in Jang v. Garland. So congratulations, David Kim.
A hardcore immigration lawyer is always like doing some crazy fighting. I don't know how he has the energy to always be on the front lines the way he is.
No, me neither. And I mean, I'll say it because I literally just saw him posted on Facebook. I mean, it hasn't been without casualties. He had a heart attack a couple of years ago, and I think part of it is from this. And that's just, more hats off to David. David's doing fine. David recovered, and he is still this fierce advocate. But you put in the time, put in the effort. I say that not out of personal knowledge. Again, literally on Facebook, I just saw that he was referencing that happened to him a couple of years ago in relation to the stress from immigration lawyering.
For sure.
But bounced back for sure.